Implied consent warnings and DUI arrest. Many drivers stopped for drunk driving mistakenly believe that they can simply refuse a blood alcohol test and avoid all penalties. However, the truth is that by simply refusing to take the blood alcohol test, these drivers now automatically face severe penalties completely independent of the DUI charge. Implied consent laws. Every state has implied consent laws. Generally, these laws make it a requirement for licensed drivers to submit a blood alcohol test if suspected of driving under the influence. By accepting the privilege to drive on state roads, you are accepting the duty to take a blood alcohol test when asked. Penalties for violating implied consent laws. Many drivers do not realize that the penalties for violating the implied consent laws can be as severe as the drunk driving charge. For example, you could face lengthy license suspension, significant monetary fine, and even a possible jail sentence. You will want to talk to a DUI attorney in your state to learn the specific penalties you could face for violating implied consent laws. Should you refuse a blood alcohol test? In some situations, it may make sense to refuse a blood alcohol test and violate the implied consent laws even though you face automatic penalties. However, these situations are very fact-specific. Drivers should remember that even a failed blood alcohol test does not necessarily mean that the driver is guilty of a DUI. There may be many reasons for a blood alcohol test above 0.08, including an improperly calibrated device or problems with the handling of the blood sample. So, it may be worthwhile to submit the blood test and avoid the implied consent penalties. This will give you a chance to fight the DUI charges and blood test results in court. Contact a DUI attorney. If you have been accused of drunk driving or violating implied consent laws, you will want to hire an experienced attorney. The penalties can be severe, and an attorney can advise you on your next steps.